Okay, welcome. Today we're going to be talking about campaigning and advocacy, the do's and don'ts for public school leaders. This webinar is a result of a lot of questions I've been getting because this is election time, November. We have a lot of override and bond elections coming up, and folks that are interested in those elections are asking lots of questions. In addition, there's been a change in the law that has gotten a lot of attention, and I wanted to talk a little bit about what that change in the law is and go over what I think it requires. So let's get started and jump right into it. My name is Chris Thomas. I'm the ASBA General Counsel and Director of Legal and Policy Services. There's my email address, and I'm always happy to answer questions from you all on this topic. Okay, so the statute we are dealing with today is ARS 15511. And here's what 15511 does in a nutshell. It affects all, first of all, it affects all elections. So it doesn't matter, it's not just, doesn't just pertain to school board elections or override or bond elections, it applies to all elections. So you're dealing with school board elections, any legislative, congressional, city, or candidate elections also applies to those. Initiatives and referenda at the state level, your propositions that come up every 2 years, and the school bonds and override campaigns. It also applies to not only when an election is called, but in the lead up to an election. So if there's a possibility of an election, say you're in the pre-override period, the 15511 restrictions would apply to that as well. And basically, it prohibits a person acting on behalf of a school district from using a school resource to attempting to influence the outcome of an election. And the definition of influence, this is the one change in the law that I want to talk about. What does it mean to influence an election or attempt to influence an election? Well, in House Bill 2156, which I'll go into a little bit more detail about, it defines what influencing an election is. And here's the definition. Supporting or opposing a candidate for nomination or election to public office, or the recall of a public officer, or supporting opposing a ballot measure, question or proposition including any bond, budget, or override election, and supporting or opposing the circulation of a petition for the recall of a public officer, or a petition for a ballot measure, question, or proposition in a manner that is not impartial or neutral. Okay, so that's a different standard than what we've been under before. So essentially, even if you were presenting the facts, what are to be considered the facts, without expressly asking people to vote one way or the other, but those facts are presented in a way that is not impartial or neutral, under the law, by definition, that is attempting to influence the outcome of an election. Now, that may have legal issues that I'll talk about a little bit, but that's the new standard. So keep that in mind as we're going through our questions and going through this law. By the way, on questions, I'm happy to take questions. I'll do the questions at the end. So if there's anything that triggers a thought or a question that you have, feel free to submit it, and we will deal with those at the end. So please do that. Okay, so this impartial or neutral provision. There's a court case known as, it's Cromco versus City of Tucson. It was decided in 2002, and it sets forth the standard legally under the old 15511, and we'll talk about that in a second. And here it is. This is from the Cromco case. It basically says express advocacy may be based on a communication that, taken as a whole, unambiguously urges a person to vote in a particular manner. The communication must clearly and unmistakably present a plea for action and identify the advocated action. It is not express advocacy if reasonable minds could differ as to whether it encourages a vote for or against a candidate, or encourages the reader to take some other kind of action. So that was the standard under Cromco. What's important is that that was based on the old language that was in 15511. Now, a controversy has come up that there have been folks, particular folks with the Goldwater Institute, who have said that that the new standard that's in 15511 now erases the Cromco decision. I don't think that that's true, and here's why. Because the Cromco decision is actually rooted in constitutional law. It refers to a couple of really important Supreme Court cases, and if the Goldwater Institute were accurate in terms of Cromco being overruled by this change, I think we have a problem of vagueness, because we have to have laws that are clear enough for people to understand what is a violation of law, what is not a violation of law. We also cannot have laws that chill a fundamental right, which is the First Amendment to the Constitution guarantees free speech rights of all citizens. And if this standard were in place, I think you could make a pretty good argument that you are chilling a fundamental right of speech. So that's all background to say that I'm not sure that the Goldwater Institute is correct in terms of the standard. I think we should adhere to the standard to try to stay out of court. That's always a good move, but I don't know ultimately whether they'll be successful in actually going after somebody under that standard. Okay, also included in House Bill 2156 was really a small provision that just said that if you're going to have a community forum for the purposes of debating an override or bond election or candidate election, well, at the same time, you can't rent your space to a private individual to advocate for an election one way or the other. We'll get into the rental use of facilities to advocate for an election later, but this is just basically saying you can't allow for that rental at the same time you're doing a community forum event where all sides are being invited to partake. Okay. Also important is in House Bill 2156 is the penalties went from $500 fine per violation to $5,000 per fine violation. Important to note about that is that comes right out of your pocket. It can't come from the district's insurance. It can't come from the district. And since it's levied on a person, it's got to come right out of that individual's pocket. Okay. More in terms of what 15511 prohibits. It prohibits school boards from making statements or submitting arguments in favor of or in opposition to a ballot measure. So a board could not pass a resolution opposing a proposition that's on the ballot. It could not pass a ballot measure opposing or supporting a candidate for public office, of any public office. But it does not include the pro statement that's required to be submitted and signed by the governing board when you go out for an override election. Essentially, that's still preserved. You have to come up with that pro statement, and the board needs to vote on it, and then that gets into the publicity pamphlet and becomes something for your electorate to consider. The meat of 15511, I think the biggest thing that it does is it prohibits school employees when they're on duty from activities that would influence an election. In addition, it prohibits the use of school property, including any equipment, paper, copiers, buildings, computers, etc., from being used to influence an election. And important to note about that is, you can't even lend any of those things because even lending them, even if they're paid back, would likely be a violation. So we'll go into more on these two last bullets because that's the meat of the law when we get into the questions. It prohibits, this was something that passed in, I believe, 2011. 15511 also prohibits school districts from expending funds for membership in an organization that attempts to influence the outcome of an election. This is the ASBA provision, if you will. ASBA supported a ballot measure that the legislature very much did not want us to. It had to do with the repeal of the First Things First initiative. And in response to that, the legislature passed 15511 aimed at trying to keep ASBA from being able to do these things so long as we have school district members. And so ASBA has complied with that and has set up alternative processes whereby a separate organization can ensure that ASBA's, or at least the voice of school board members, that their voice is recognized in election matters, and that's the Friends of ASBA, which is a whole other presentation, so I won't go into it. It also prohibits students from being given campaign material intended to influence an election or material intended to influence the outcome of legislation. Now, that's a new concept that we're introducing right now. The only time 15511 restricts a lobbying effort towards legislation is with regard to giving materials to students. So otherwise, 15511 does not concern itself with school employees letting their positions be known at the legislature. Now, there may be other restrictions on that, but 15511 doesn't cover it. This provision only makes it clear that students can never be given campaign material, and that is an absolute rule. Even material that is factual in nature, that is related to a campaign, I would not recommend giving to students. It's just such a bright line. Okay, so we talked about what it prohibits. Let's talk about what it does not prohibit. It does not prohibit individual board members or school employees, when they're not on duty time, from exercising their free speech rights and being involved in campaigns to the extent they want to be involved. Of course, there cannot be any compulsion by school staff for employees to do those kinds of things, but school employees and school board members, if they're acting in their individual capacities and not using a school resource, absolutely can be as involved as any other citizen can be would like to be involved. School district employees may receive campaign information in their school district email accounts and mailboxes from an outside non-school sender. So it's just the receipt alone of that kind of material is not a violation, so long as it came from an outside sender and that outside sender was able to receive those accounts and that information to send it in the normal legal way. Information that's, once it's received from these accounts, cannot be forwarded to outside recipients or to home accounts of employees. I've had that question come up a number of times where school employees have said, well, I received it, so that's not a violation, and now I would like to forward it to my home address where I can print it out and use it. That would be an illegal use of school resources, because you're using the school email system to forward a message that is an attempt to influence the election. So I would not advise that you do that. Okay, what it also does not prohibit is that the outside groups, including parent-teacher organizations, they can organize and use school buildings to have meetings in support of a campaign, providing that those groups lease the facilities in the manner any other group would be allowed to lease, and they don't get any favorable treatment over any other outside group. That is okay under the law. Also, individuals can exercise their free speech rights, including politicking, including flyer distribution, at an event in which the public at large is welcome, providing that all groups are welcome to engage, both pro and con, and it is consistent with the district policy for such activity. Also, what 15511 does not prohibit is that school districts can remind their patrons that there is an election in November. They can say what the election date is, but they cannot obviously, and they can suggest that they vote, but they can't suggest in any way, shape, or form how to vote. So if you had on your outside marquees, election November 4th, please vote, that is not a violation of this law. Board members and school employees on a school district time may answer questions from a factual perspective on the impact of the school district depending on the election's outcome. Remember, a select presentation of the facts designed to persuade very well may be seen as a violation under the new standard of law. So if your goal is to avoid even the allegation that there is a violation of law, which I think that should be your goal, you don't want to do, you want to make sure you give out all the facts, including, for instance, what the tax rate might be if the override does not pass, including other plans that the district may have for improving the school absent override funds or bond funds. Okay, so that's the nutshell of what the law is. Now we're going to go into the frequently asked questions that we get. I've logged for this and on this subject, and I should say that we do have resources online, including a copy of this FAQ online. If you go into and do a search of school resources at the www.asbba.org site, you will find it. And hopefully that's of use to you. So the first question is, can a person use their title in support of an issue, say a letter to the editor signed by the superintendent? Well, the answer is yes, although I think that best practices may be different depending on who the person is. Superintendent's a particularly problematic one because superintendent is a job that is a 24/7 job. You're seen as a superintendent no matter what. So if I was a superintendent, I would not, the best practice would not be to identify myself as a superintendent, or at least at a minimum to write in the letter that they are not writing from their position as superintendent, but rather as a citizen. An even better course of action would be for individual board members, or better yet, the person who's in charge of the override or bond campaign to actually write that letter instead. That makes it much easier and much cleaner and avoids it. But the issue then is it legal? Yes. Is it advised? No. Can you post election info on the school district marquees? Yes, you can put the election date and ask people to vote on the school marquee. We just talked about that, but you cannot tell them or suggest to them how to vote. Now, somebody has asked me this question. They said, well, then don't we have to do that for every election? Well, that would, again, be a best practice. City election, put up city election date when that comes up. But I don't think it's legally required. Okay, this is a longer one because it gets into a few issues. Again, can school district employees receive election-related material in school mailboxes, or on school computers, or in school provided email accounts? And the answer is yes. We talked a little bit about that, but there are school resources issues around this. One is access. Those email addresses, how were they obtained? Did they just call the principal up and the principal gave them to them? Would they do that for anybody? They should make a public records request and get it in the proper channels. Same thing with physical mailboxes. If you do that for the campaign, you've got to do that for everybody. It's all about equal access. Also, if you do get a message that's sent to you, you can't print it off on a district computer. You can't forward it from your email account, district email account, to your personal email account. That action, you're using a school resource to further an election purpose, and I don't believe you can do that. A good practice is for any messages going to school district email accounts to contain a tag that informs the receiver of the message and advises them really what they should not do. And that language is there for you to consider. If you are going to do this, we don't want to be getting school district employees in trouble if we can help it. Okay, our next question, can a parent or employee have a political or election-related bumper sticker on a car in a school parking lot? Yes. The Attorney General guidelines, which I still believe are good law, or at least a good advice, they're specifically addressed that, and I do believe you can have a political sticker on a school parking lot without violating the law. Now, I have seen people take this to the extreme, and there's certain practices I've seen that make me a little uncomfortable. A school, a car parked permanently on the school parking lot that has huge sandwich boards and huge billboards attached to it about the override, that's probably not going to cut it. But the bumper sticker, I think you're probably okay there. Okay, can teachers wear t-shirts or buttons to school in support or opposition to a ballot measure? Can board members wear t-shirts or buttons in support of a ballot measure to a board meeting? The answer to those questions are no. Can community members, parents, or school employees pass out material in support or opposition to a candidate or ballot measure at school or school-sponsored events? And this was one that gets tricky. Yes, they can if the event is where the public, if it is an event where the public is not generally invited, like during the school day, parents or community members would have to stay off school premises to hand things out. So if they were on the right of way, and of course, hopefully not impeding traffic or causing a safety issue, they could do that. If it's during an extracurricular event on school campus, that's one where and if the public is invited, and it's also one where we allow some kind of political or public forum for free speech, then yes, the employee, if they're off duty, can pass out material, same as the community member can pass out material. But for school employees, be very, very careful about this. Whether you're off duty or not may seem, yes, are you getting paid for it? Maybe not. But what would happen if, say, there were an emergency situation that demanded some response? Would you be obligated to do something about that emergency situation, being a school employee? And that sort of, begs the question whether you're truly off duty. And so that's one where, honestly, in the best case scenario is really for the community members to take the lead on that, the PTO organization. Can a district distribute factual information about the impact of a ballot measure to the public? Absolutely yes, but facts have to be presented fairly, completely, and without bias. And if at all possible, those materials should stick to just the facts, financial numbers, and avoid any semblance of an editorial comment. Can schools send home factual information with students for their parents to read? As I mentioned before, the law is very clear that students should never be used for an attempt to influence the outcome of the election or the attempting to influence the outcome of legislation. So therefore, I really do strongly recommend that any kind of campaign-related material is never given to students to take home. Can teachers, school staff, and administrators discuss their support for or opposition to a candidate or issue-based ballot measure during the course of the school day or at official events? While teachers and other school employees do have the right of free speech during the workday, those rights are very few in a work environment, especially when you're working for a government entity. And so really we're talking about non-duty time. And so school employees can gather if they're on non-duty time and they're not using a school resource to have a discourse with their fellow employees. They, however, should refrain from expressing their views about the election to students during the school day, even when asked a question. And if they're discussing ballot measures before community groups, superintendents or principals, because again, the nature of their job is a 24/7 job, they really should take time off from work if it's to be there other than a factual resource. And because it's such a slippery slope and you never know what kind of questions are going to come up, again, I would err on the side of caution on that and take time off if you can. Can school buildings be used by outside groups for campaign-related events? Yes, as long as the facility is rented at the going rate under the district's community use policy. And that includes PTOs that normally get free use for their meetings. So if you're a PTO and you normally get free use, but now you're going to be doing an election-related activity, you should go through that same process of renting the facility for that particular meeting, or for at least the portion of that meeting that is related to election issues. Can the district or school have a campaign forum on ballot measures or candidates where all sides are represented? Absolutely. And if such a forum is held, no rental charges would apply. Remember the new restriction, however, that if you do have one of these forums, you can't also have the PTO on campus renting the facility, holding a pro campaign at the same time. That is now restricted under the law. Can the band and cheerleaders perform at a ballot measure rally? You know, yes, but their performance has got to be truly voluntary on behalf of the students, and the district can't provide their uniforms. If they have district provided uniforms, instruments, or transportation, that cannot be utilized for this event. Can teachers take parent emails and send a pro or anti-ballot measure message to them from their own computers at home when not on school duty? Okay, so the teachers have parental emails. They normally correspond, and now they're going to send their own personal message from their home computer to parents. I'm really uncomfortable with this practice, I have to tell you, but it is done, and you can argue that the teachers have a right to participate if it's on their own equipment. There's no school resource being used. But the issue is then, you know, those email addresses, how are they obtained? I mean, if you're using the same email addresses you do that you got in the normal way to correspond with parents for official purposes, I think you're going to have to go through the motion of, and it seems redundant, but you're going to have to go through the motion of making a public records request for the particular purpose of getting those email addresses at home and utilizing them that way. Can a school board adopt a resolution in favor or opposed to a ballot measure? The answer is no. Can civic educators discuss ballot measures as part of a kids voting program or other type of program to teach students about the political process? Yes, as long as the instructor follows a curriculum that is neutral in its approach, while students are free to voice their own positions about ballot measures during such a program, and school employees, however, should refrain from doing so, and that is expressing their own positions about the measure. Can voter registration material be given out by schools? Yes, but it is advised that that only be done as a part of an ongoing effort and not just about surrounding a particular campaign. If a school gives out space to an outside group for free under its community use policy, where the activity supports the school's educational mission, can that outside group allow campaigning by a ballot measure? So you've allowed, under this community use policy, you've got a good, you know, maybe the Cub Scouts or the Boy Scouts, and they're allowed to use, because they support the school's educational mission, and they also have a civic component, they want kids to get involved. Could they have a meeting about supporting the override? The answer is no. For that particular meeting, they would have to pay, just like the PTO in our other scenario did. Do 15.511 restrictions apply to charter schools? The answer is yes, they do. Although charters are exempt from most of the laws pertaining to school districts, they have to follow 15.511, and all the answers that we are talking about here would apply equally to charter schools. Our 19th question, can pro-ballot measure signs be placed on school campuses on election day if the campus is being used as a polling place? Yes, actually that's one exception. If the campus is being used for a polling place, there's a First Amendment right involved that, you know, outside of the zone where no speech matters are allowed to be entertained, you know, as long as all sides are equal, those measures, those signs could be put up for that particular day, but then they'd have to be taken down immediately after and only there on election day. Can students attend ballot measure rallies held on campus? Yes, but only voluntarily, and information about the rally cannot be distributed during the school day or using school resources. Also, that the facility for the rally must be rented under the school's community use policy. 21, question 21, can districts have a forum where only facts and local impact will be discussed regarding ballot measures? Again, yes, a just the facts presentation is allowed. Again, but I do think that neutral facts have to have both pro and con. And even if, you know, that the con side's not represented, somebody ought to play devil's advocate and offer the con message. Can education organizations endorse and support ballot measures? Again, this is going on the ASBA provision. Not if they have school districts as dues-paying members, or if districts pay membership dues to the organization on behalf of an individual member. That would also apply to groups like the school business officials, the school administrators, the school personnel group. I mean, every alphabet group that deals with school employees. If the district pays those dues, then that organization cannot endorse a particular point of view on election issues. And I mentioned briefly the Friends of ASBA. The Friends of ASBA is not funded from school district dues. They do not have school districts as members. And so therefore, they are not under that restriction. So if that's the question you're wondering about. Okay, and then I've got some other questions here that have been submitted in advance that I want to take care of before entertaining any questions that have been submitted, but I also want to invite you again to offer a question for discussion or for me to try to weigh in on right now so that we can get to them at the end. So here we go. Some of these may seem familiar to, if some of you attended the forum that was, I think, in August, put on by the Arizona Citizens for Quality Education. I was a panelist there, and many questions came to me. So they were really good questions. I wanted to have those as well to talk to you all about. So first one is, if an elementary district is not out for election, but a feeder high school district is, can the elementary district promote the high school election? The answer to that question is no. Remember, it doesn't have to be your election. It doesn't have to be the fact that the school district has a stake in a particular election. It's all elections matters. So even if it's the high school district, elementary district is restricted from using school resources to influence the outcome of the election as well. Can we present factual information to coffee talk groups that meet at schools? And what can we put on our websites? Again, yes, you can present information to coffee talk groups. If it's a school employee who is meeting with one of these groups, you have one of two choices. You go as a school employee on duty-bound time, and you answer purely from just the facts point of view. The other one, the safer one, is to take leave time if you're a principal or superintendent or somebody like that. Take leave time and then present to that group. Again, answering any of their questions, and then you don't have to worry about anything slipping in outside the just the facts kind of approach. Can a campaign or school district poll to determine its message and targeting? Good question. This is done a lot in bond and override campaigns. The district cannot. The district cannot pay for a consultant to poll to find out what issues the community is interested in, such that they use those results to craft a ballot, a package of proposals in an override or a bond election campaign. That you cannot do. However, can the school district campaign, which is separate from the school district, do the same thing? Absolutely. Again, the restrictions are make sure that that campaign gets all of their information, such as phone numbers and addresses and things like that, are needed to poll through the normal means through a public records request. Is it possible to organize, is it possible for a government teacher to organize 18-year-olds to register to vote? Yes, they can. They can do that, and that's okay. Again, so long as it's not met with any kind of, it's not part of an advocacy campaign relating to a particular election or meant to influence the election, registering 18-year-olds to vote is okay. Okay, a couple other ones. Can money for the district PAC be collected through education association website? So I assume we're talking about a separate PAC run by an outside entity for the purposes of influencing the election. And the question is, can education association websites, which also are private entities, can they collect that money through their websites? And the answer is yes. There's no district resources involved. And again, so long as the individuals involved aren't on duty time doing all of this, that's fine. Can students canvass neighborhoods? Absolutely, they can, so long as it's voluntary, and so long as it's not, you don't prompt their participation during the school day, but they absolutely can do so. What role can a district foundation pay in a bond or override election? Is the role the same if the district is loaned a district employee? Well, school district foundations are separate organizations. However, they have some restrictions because they usually get space for free. Sometimes the superintendent is an ex officio kind of employee of them, or they may have a district loan employee for the purposes of doing that. I don't think this is your best move to have the foundation involved, but if you do so, then make sure that it's kept separate. And if that district loaned employee, if they've been loaned to the foundation, they obviously can't be used for election-related activities on behalf of the foundation. That's going to be a problem. So with that, those are the questions I had to answer that I wanted to repeat from the ACQE forum. And now I'm happy to entertain any questions you all might have. Okay, we're gonna. Okay, if you rent the facility for use by a group or in support of election, where's the whole question? Is that permitted? If yes, what is considered the appropriate fee? Can it be minimal? If all groups would be charged minimally for similar group use? I think the point is that the fee has got to be, well, the statute under 151105, which is the community use of facility statute, says you at least have to recoup the actual facilities costs, like the electricity, the janitorial services, just the basic, your basic cost as a district. So that's a minimum fee. But under 15511, you also have to make sure that you're charging an amount that you would charge an outside group to come in. I mean, if you had an outside group that came in that was running a for-profit soccer club, what would you charge them? I think you have to charge them, you have to treat all classes of groups the same. And in essence, the groups that are trying to influence the outcome of the election can't get a better deal. Okay. Next one. Can a local teachers association use their funds to promote the ballot measure? Yeah, they can. I mean, those are private funds. Again, so long as the people involved aren't on duty time when they're involved in it. In your opinion, can parent-teacher groups provide information through their electronic newsletters to parents regarding elections? Okay, they encourage a yes vote. The question there is then, okay, really what you need to make sure, though, is that you're not using a school resource. So if it's a parent group and you've obtained the email addresses through a public records request and you're sending it to parents, absolutely you can. Now, if you include it in a newsletter and it's distributed in the same manner through the school, like a lot of parental newsletters using an email address that's provided by the school, then you got a problem. But if it's all private and it's going from the outside parent groups to parents, you don't have a problem. If a staff member has their email automatically forwarded to their home mail address, will that be a problem in regard to the use of school property? Well, in a technical sense, yes, but I think if it's synced for all of your email, it's got to be a tough one to do. That I'd have to think about that a little bit more, but I don't think so. because it's not like you're doing something special, I think, for this issue. Let's see, would a district be allowed to give a local teachers association's names and addresses of school employees in which they would provide a letter composed and distributed outside the district? Again, the issue there then is, how did they get the names and addresses? I think the district can provide the teachers association the names of addresses of school employees, so long as the teachers association made a public records request, and that information would be given out to a different group who asked for it. If it's truly public record, then absolutely you can give it. It doesn't matter what it's going to be used for, unless it's a commercial purpose, which is different. Okay, will this PowerPoint be available for us, and when? It certainly will be. I'll let Mike, when are we going to do with it? We can put the PowerPoint up on our website. If a PAC is speaking to a PTO meeting and the PAC pays for the time to speak, does the PTO also have to rent the time? As long as somebody is paying for it and they're paying the going rate, I don't think you have a problem. It doesn't matter if the PAC pays for it or the PTO pays for it. Can signs be used on the day of an election if the election is an all-mail ballot? I don't think that changes the analysis at all. Oh, well, I guess, I think it does. I mean, if you certainly can't use the polling place exception on that day. You can't allow pro or con statements on school grounds if there's no polling place being served there on election day. So I think, yeah, the more I think about that analysis just doesn't apply if there's no polling place there. Can a PTO endorse a measure if they have a teacher's liaison in the PTO? Yeah, I think so. I just think the teacher liaison probably, the best practice would be that they refrain from voting on that issue. What is the definition for a salaried employee being off duty? Good question. If you attend events, answer emails and phone calls in the evenings, and attend some events on the weekends, can you ever present information as an individual? And that, I definitely have sympathy there. I mean, we have superintendents really never stop being the superintendent. Principals never stop being the school principal, particularly if they're in on the school campus or on a district facility. So I think the best practice is for a superintendent or a principal, they really never can take that hat off if they're in a school or district facility. If they're outside of a school district facility, I don't think that they shed their First Amendment rights by accepting such a position. But I think the criteria for them separating themselves is a little finer, and I really do think that they need to take that leave time, put in a leave slip for an hour, half hour, whatever have you, so that if there is a complaint made, you have something to fall back on to show that, really I was acting as an individual at this particular point. Can a superintendent give factual presentations about the override as long as there are other agenda items? Yes, of course they can, but again, even a factual presentation, you really need to be careful about balancing those given facts so that taken as a whole, it doesn't look like you're attempting to influence the election. So if you're going to say what the money would be used for, the override, the things you would do with the override, you also have to say, that the tax rate may go down if the override doesn't pass. You have to know what the con argument is, in a sense, and at least present that in a factual way as well. Okay, under the new law, can a school district publish information such as, if the override renewal does not pass, items that could be considered for reduction or elimination include time in music, art, and PE classes? Okay, that's a good question. That is, can you go back to it? I want to be able to see it again. That's one where, under the new standard, someone's going to, if you presented that information, somebody's going to allege that you're not presenting it in an impartial manner, that you're nudging people to vote a particular way. And so boy, that's a tough one. if your goal again is to avoid the allegation of a violation, I would say no. If your goal is to just stay on this side of the law, I think you probably can say that. Okay. Okay. Does anybody have a good example of a public records request? Well, yeah, in your district policy, your policies have a form, an exhibit that you can print out, and you should fill out the form and use the same form everybody else does. Can a school board member acting as an individual give factual or opinion about an override or bond measure to a PTO meeting on school grounds during the day if the PTO does not pay for the facility? Okay, the question is, if the important issue there is if the PTO does not pay for the facility. And if that's the situation, then I think, yes, the school board member has to stick to a just the facts presentation. If the PTO member does pay for the facility, the school board member as an individual has no power. And unless they've been sanctioned by the board to do so, there's no school resource from a board perspective, so they can give opinion and even campaign if the PTO is actually paid for the facility. Okay, that's the last of our questions. Those are all really great questions. And again, I just want to let you know the resources we have. The PowerPoint will be up on our website. We have a document that has the guidelines, including the FAQ of all the questions I discussed, at least the first questions I discussed, on our website. And I'm also available as a resource if you have questions. You can email me. That's kind of the best way to get a hold of me. cthomas@asba.org, and I'll be happy to answer your questions. Just know that I am there to give you legal information, sort of inform you as to what the law is, but I cannot be your attorney, and I am not there to give you legal advice. So we will also put this entire webinar presentation on YouTube. So for those of you who want to watch it again, because it was so riveting, almost as riveting as the finale of Breaking Bad, by all means do so. If you know somebody who would like to see this that missed it, point them in that direction. So thank you all very much.